Greetings and welcome to Law of Evidence, Judicial Notice from American Jurisprudence. So, this is one of my favorite sections of Law of Evidence here from the evidence of American Jurisprudence, second edition, 1998. Although it is rather old, some of these elements here are pretty timeless as far as it goes this far with the law. But again, this is only to be used and not to be misused or misconstrued or misused for anything other than the entertainment and educational purposes of this YouTube broadcast. So it's not to be used for any of your professional, personal, legal, lawful, business, tax, or otherwise purposes. Don't do this at home. That being said, let's get started. So, judicial notice. This is in Title II section here. A, introduction in general. So, section 24, generally. Judicial notice is a substitute for formal proof of a matter by evidence. The phrase judicial notice refers to the method by which a court informs itself of a particular fact during the course of litigation without the use of formal evidentiary proof, when there's no real necessity for it because the facts noticed are indisputable as a matter of notorious common knowledge, or as being easily capable of immediate verification. So, judicial notice is a substitute for a formal proof of a matter by evidence, but it would be something that it's informing the court itself when there's no real necessity for any kind of formal evidentiary proof, and only because facts noticed are going to be either indisputable or being easily capable of immediate verification. Judicial notice is used cautiously and only when facts judicially noted cannot reasonably be disputed. So that's footnote 89. Interesting. Let's check that really quick here because before I comment, let's see here. Footnote 89, section 31. Well, we'll get to that eventually. So I wanted to comment on this section here. Judicial notice is used cautiously and only when the facts judicially noted. The facts judicially noted cannot reasonably be disputed. So this is what they're recommending to their practicing esquires. Judges do not like judicial notice, so it's used cautiously and only when the facts judicially noted cannot reasonably be disputed. We'll get into that in detail in section 31, it seems. When the rule is invoked for general evidentiary purposes, the trial court has the power to dispense with proof of judicially cognizable adjudicative facts. Judicial notice cannot, however, be used by a party to fill in the gaps in the party's evidence. And it is a better practice to bring into evidence those facts that a party desires a court to judicially notice. In fact, some courts require that the documents or exhibits a party wants the court to judicially notice must be offered and brought to the attention of the trier. So this sounds like it's almost evidence here, right? And what rules of evidence would this apply? I would be curious about. Let's check over here to the chat and see if anyone's noting any of this too. Metal is becoming a quasi-lawyer. Be careful. Okay, why have it if the judges hate it? Sounds odd. You're about to see, if you pay attention to why it puts a lot of work on their table. And, they just, why do unnecessary work in their eyes? But, again, this is something that it puts a lot on the line. It's a judicial notice is going to be a substitute for evidence. And it's the court notifying itself that there's an indisputable fact or self-verifying fact that it can notice without any risk of breaking the law. So this is why they don't like to use it. So when a rule is invoked for general evidentiary purposes, when the rule, which is of judicial notice, the trial court has the power to dispense with proof of judicially cognizable adjudicative facts. So judicially cognizable have to be known from a judicial perspective, and adjudicative facts, the ones that can go through the back and forth of adjudication, and they can dispense with proof of facts that, I guess, judicially cognizable and adjudicative. Judicial notice cannot, however, be used by a party to fill in the gaps in the party's evidence. So that's why it can't be an absolute substitute. It can't be used to fill in gaps in the party's evidence. And it's a better practice, of course, to bring into evidence those facts that a party desires a court to judicially notice. In fact, some courts require that the documents or exhibits a party wants the court to judicially notice must be offered and brought to the attention of the trier. Similarly, a party who depends upon the taking of judicial notice by an appellate court of local conditions within the judicial notice of the trial court should make sure that this knowledge is brought into the record. So, a party who depends upon the taking of judicial notice by an appellate court of local conditions within the judicial knowledge of the trial court, should make sure that this knowledge is brought into the record. So if you depend on the judicial notice, it would be up to you to take it, make sure it's brought into the record. Okay, it seems like a practice tip there, but let's see, footnote 91. Hammond versus Duty, and that's the case. All right, let's get back to where we were here. All right. Furthermore, judicial notice must not be used to deprive an adverse party of the opportunity to prove a disputed fact. So again here, they're supposed to be indisputable as a matter of notorious common knowledge. If it's not that, then it must be proven. It would be a disputed fact before it would be entered as evidence. The principles of judicial notice will only apply to cases where three prerequisites are met. First, the matter must be one of common knowledge, although it does not have to be universally known. Okay, common knowledge, but it doesn't have to be universally known. Second, the matter must be settled beyond a doubt. If there is any uncertainty about the matter, then evidence must be taken. Third, the knowledge must exist within the jurisdiction of the court. Judicially cognizable. There we go. So one of the beauties of American jurisprudence is they do repeat and reinterpret the same concepts from different angles, the different faceted ways of looking at it, to give you the best way of having a full comprehension of the legal concepts at hand and how they coincide with the common law aspects of American jurisprudence tradition. And then you have the practice tips. At the same time, you also have where you see here where it's used with caution, and that's one of the general sentiments of that brotherhood, so to speak. So you'll see that intertwined into American jurisprudence as well. And I like to do these presentations here where we can all notice all the different aspects of it and take with it the best understanding of the law. Let's continue. Furthermore, judicial notice must not be used to deprive an adverse party of the opportunity to prove a disputed fact. Big point. So, we have here the 3 prerequisites. Matter must be of common knowledge, but it doesn't have to be universally known. Must be settled beyond a doubt, no uncertainty. And the knowledge must exist within the jurisdiction of the court. So your three-part test for the principles of judicial notice. So all 3 of these, it seems here, where 3 prerequisites are met, will only apply. Okay, the principles will only apply. There we go. So good to read into these deeply. Section 24 is our supplement. Again, this is from 1998. Case authorities. In inmate suit challenge, disciplinary proceedings conducted under the defendant's discretion, court would take judicial notice, as requested by plaintiff's counsel, of transcripts of prior testimony in other cases involving defendant, since defendant did not object or contest accuracy of his statements in those cases. Because normally you wouldn't be able to enter in as evidence a testimony from another case, but in this case, okay, so here's something we just learned, that by using judicial notice, a court would take judicial notice required by the plaintiff's counsel of transcripts of prior testimony in other cases involving defendant, since defendant did not object. He could have objected to that or contest accuracy of his statements in those cases, because under the rules of evidence it would be considered hearsay. All right, now we have court would not take judicial notice of fact that nearly all currency contains detectable traces of illegal narcotics, since such fact is neither commonly known or readily determinable through unquestionably reliable source. Wow, 94. I wonder if that's changed since then. Remember, this is a 1998 supplement we're looking at here. Quite interesting. District court's use of sex discrimination suit by another woman arising out of same promotion of male coworker as basis of instant suit to find that plaintiff was without remedy under Title VII was not instance of judicial notice, since fact found in other suit that the other female was most qualified for promotion was not universal truth, but fact to be established through presentation of evidence. Wow. Interesting one there. So it's not a universal fact that she was more qualified. In suit by government against physician for reimbursement of National Health Service Corps scholarship funds. Oh gosh. Court improperly took judicial notice of findings by another district court in another lawsuit involving physician, since findings in another suit did not indisputably establish that physician refused to work for health center to which he had been assigned. That sounds a little complicated there. And here are footnotes. Forms. Notice request that judicial notice be taken. That's a good one. Notice, here's another one. Notice for appointing expert witness to allow court to take judicial notice. Ooh, that's a good one. Motion here for judicial notice of statute of sister state. Whoa. Here's a motion for judicial notice of statute of sister state. Another form. Here's affidavit or declaration. In support of motion for order appointing expert witness to allow court to take judicial notice. And then we have an order. We submit this proposed order to the judge, I would assume, appointing expert witness to allow court to take judicial notice. And instruction to jury. Establish evidence established by judicial notice. Distance along highway. Wow. Pretty cool forms here. And these all come from the AmJur pleading and practice forms. Judicial notice is intended to avoid the necessity of formally introducing evidence in those limited circumstances where the fact sought to be proven is so well known that evidence in support of the fact is unnecessary. All right. And petitioner's testimony and other proceeding concerning events constituting the crimes for which he is on trial does not fit the above quoted criteria. All right, we're on to section 25. Let's check over to the chat. So both parties have to agree. That sounds like an impossible set of rules. An esquire can act quasi, not accept a well-known fact, and refuse judicial notice. I think that in this case there was no reason to dispute the accuracy of the testimony presented in the previous case, and I think the opposing counsel just felt there's no reason to argue something like that, and they just they weren't going to object. And without an objection, then it's noted. It would be accepted by the court, and it would be noted, and it would be accepted as have that same weight as the evidence. And we have, let's see here, Bill Thomas says, if you do not object to preserve your right to appeal, the state can get away with all kinds of legal errors. I'm not sure that was necessarily a failure to object. I think there was no real legal basis to object because there's probably accurate testimony. And for whatever it's worth, it might have been corroborating other evidence that was there, and by trying to hold it back would look dishonorable. All right. Again, that was an inmate case, so you never know all the complexities behind those. All right, and let's see here. Wow, chat needs to be refreshed here. Give me a moment. And let's continue on. All right. So we're on to section 25, relevancy of information required. In order to be admissible, evidence must be relevant to the issues in the case. Therefore, judicial notice may only be taken of relevant matters. Consequently, while a state Supreme Court may take judicial notice of the records of any court of its state, the party desiring that judicial notice be taken of a record must show the relevance of the subject record. Similarly, a court will not take judicial notice of a transcript of oral argument before the United States Supreme Court where nothing in the transcript of the oral argument is relevant to the proper resolution of the case before the court. Wow, it's footnote 97. Section 139. Well, maybe not tonight. We'll get to that, but that's an interesting one there. Okay. Section 26. Use of encyclopedias, textbooks, and dictionaries. Now, this is a very important part. I hope everyone's paying attention for this. Let's do it. Since judicial notice is not limited by the actual knowledge of the individual judge, judges may refresh their memories upon matters properly subject to judicial notice from encyclopedias, textbooks, dictionaries, or other publications of established authenticity. For example, the Physician's Desk Reference is a reference book universally recognized as having reasonably indisputable accuracy, and consequently, judicial notice may be taken of the book for some purposes. Remember the judicially cognizant relevancy? A court will decline, however, to take judicial notice of warnings contained in the Physician's Desk Reference where they are referred to in a prescribing physician's deposition, but not identified by the doctor and not properly made part of the deposition, if the court cannot be certain that subsequently filed copies of warnings contained in the reference book are of the same date as those which the physician referred. Oh gosh, you can see where that one's going. In addition, reference may be had to standard dictionaries for the purpose of determining the common meaning of words. The mere appearance of facts within such publications does not, however, in most jurisdictions, entitle them to judicial notice unless they are such as to be part of the common knowledge. So this brings to mind Black's Law Dictionary and how that could be noticed, definitions within that. So, in some jurisdictions, dictionaries, encyclopedias, and similar general reference works may be consulted to determine whether a particular fact is widely enough known to fall within this category of common knowledge. The rule regarding taking judicial notice of facts appearing in texts is different in jurisdictions which adhere to the rule that judicial notice may be taken of facts not of general common knowledge, provided they can be verified to a certainty by reference to competent authoritative sources. Footnote 5. Let's see here. Footnote 5. Section 34. Well, we should be there shortly. Let's see here. Regarding a witness refreshing her memory. Oh, gosh. Annotation. Judicial notice of diseases or similar conditions adversely affecting human beings. That's in American Law Review. Okay, well, why did I even read that? For a discussion of taking judicial notice of matters of common knowledge, see Section 33. We should be there shortly. All right, now we're on to, I guess this is Title 2 of types of facts or data in general. So, generally legislative facts, Section 27, definition. Legislative facts are those facts which have relevance to legal reasoning and the lawmaking process, legislative, whether in formulation of a legal principle or ruling by a judge or court, or in the enactment of a legislative body. Footnote 6, that's our advisory committee note to the Federal Rules of Evidence. When a court, as a basis for making law, assumes or reaches a conclusion as to a broad proposition of fact, the court is said to have taken judicial notice of legislative facts. Quite often, in reaching and in justifying its conclusions, a court will take notice of scientific, sociological, and other data which itself may be disputed. For example, the United States Supreme Court has taken judicial notice of the primary purpose of a statute in that custodial integration is inherently so psychologically coercive that any statements elicited during such interrogation are per se coerced, in violation of the Fifth Amendment privilege against self-incrimination, unless detailed procedural safeguards, including what are known as Miranda warnings, are followed. What a nice, convenient technicality, huh? So, do you see what this means here? Legislative facts. Custodial interrogation. I misread that before. So, custodial interrogation, when they're holding on to you here, is inherently so psychologically coercive that any statements elicited during such interrogations are per se coerced, in violation of the Fifth Amendment privilege against self-incrimination, unless detailed procedural safeguards, including what are known as Miranda warnings, are followed. All right, so followed. Section 8, footnote 8, Miranda versus Arizona. We know that one. And footnote 7 was Superior Court of Sonoma County. The court took notice that the prevention of illegitimate pregnancy among teenage girls was a primary purpose of the challenged legislation. Then cited considerable sociological data showing the frequency of teenage pregnancies, the usual negative impact of such a pregnancy has on the female involved, and the overall societal impact of the problem. Wow. They must have had a good expert witness to get that all pushed. Of course, California. Concerning judicial notice of legislative intent. All right, we're on to section 28. Let's jump over here to the chat and catch up with where we left off here. And there it is. We're all refreshed. Let's continue on. So we're on to section 28, elementary factual data, evaluative data. In addition to adjudicative and legislative facts. Two other aspects of the fact-finding process are also sometimes discussed in terms of judicial notice. Wow, so we learned about the adjudicative, right? The ones where there has to be within their jurisdiction and within the common knowledge and no dispute. The legislative, which is about the lawmaking process there. And two other aspects of the fact-finding process are also sometimes discussed. The first is what might be called elementary factual data. As the advisory committee, that's the advisory committee to the Federal Rules of Evidence, drafted the Federal Rules of Evidence, has commented, every case involves the use of hundreds or thousands of non-evidence facts. For example, when a witness in an automobile accident case says the word car, everyone, judge and jury included, furnishes from non-evidence sources within herself the supplementing information that the car is an automobile. The judicial process cannot construct every case from scratch. These items could not possibly be introduced into evidence, and no one suggests that they should be, nor are they appropriate subjects for any formalized treatment of judicial notice of facts. So, elementary factual data. So that's the term, and that's in quotation marks. So if you're ever questioned about, something that's so simple as using car for automobile or, people trying to play semantic games, elementary factual data is how you can establish your terminology. The other aspect of the fact-finding process, sometimes discussed in terms of judicial notice, is referred to as evaluative data, which has been described as non-evidence facts to appraise or assess the adjudicative facts of the case. So, oh gosh. Footnote 12. That's the advisory committee. Oh, this would be an interesting one to do an update on, is the advisory committee note to the Federal Reserve, Federal Reserve, the Federal Rules of Evidence. All right, we're on to section 29. Distinguishing between judicial notice of adjudicative fact and other types of judicial notice. And let's jump over here to the chat. Make sure this is all up to date, and indeed, let's proceed. The precise line of demarcation between adjudicative and legislative facts is not always easily identified. I was having a feeling it wouldn't be. Adjudicative facts are usually those facts that are an issue in a particular case. Such facts relate to the parties and to their activities, properties, and or business. When a court finds facts concerning the immediate parties, who did what, where, when, how, and with what motive or intent, the court is performing an adjudicative function, and the facts are conveniently called adjudicative facts. Stated in other terms, the adjudicative facts are those to which the law is applied in the process of adjudication. They are the facts that normally go to the jury in a jury trial. Thus, judicial notice of adjudicative facts dispenses with the need to present other evidence or for the fact finder to make findings as to those particular facts. Legislative facts, on the other hand, do not relate specifically to the activities or characteristics of the litigants, but are general facts which help the tribunal decide questions of law, policy, and discretion. So those are legislative facts that can be judicially noticed to help the tribunal decide questions of law, policy, and discretion. Interesting. So another reason judges don't like judicial notice is because by using legislative facts, you can put them on notice about, you can help them decide questions of policy and discretion. They can be described as established truths, facts, or pronouncements that do not change from case to case, but apply universally. Legislative facts are those which have relevance to legal reasoning and the lawmaking process, whether in the formulation of a legal principle or ruling by a judge or court, or in the enactment of a legislative body. So they have their courts too, remember. A court generally relies upon legislative facts when it purports to develop a particular law or policy, and thus considers material wholly unrelated to the activities of the party. So the court generally relies on legislative facts when it purports to develop a particular law or policy. What do they call that? Legislating from the bench, and thus considers material wholly unrelated to the activities of the parties. In the great mass of cases decided by courts, the legislative element is either absent or unimportant or interstitial, because in most cases, the applicable law and policy have been previously established. But whether a tribunal engages in the creation of law or policy, it may need to resort to legislative facts, whether or not those facts have been developed on the record. Though a court, with its adversary procedure, is not necessarily precluded from resolving issues of legislative fact, it is generally thought that their determination is particularly appropriate to the administrative process, in which staffs of specialists and great storehouses of information are available. So, the comment here, counsel should be aware that judicial access to legislative facts is not subject to a limitation, as in Federal Rules of Evidence 201B, in the form of indisputability. It's not subject to a limitation. Judicial access to legislative facts is not subject to a limitation in the form of indisputability or to any other formal requirements of notice other than those already inherent in the affording opportunity to hear and be heard in exchanging briefs and in any requirement of formal findings at any level, in that judicial access to legislative facts should leave open the possibility of introducing evidence through regular channels in appropriate situations. That's footnote 24. Interesting there. Okay, it's advisory committee. This one here, they're a little overbearing, it seems, that advisory committee. They really want to have a lot to say there. And again, that's not the law, the advisory committee. So these are things that could be disputed in any case. 24, there it is. Okay. The Federal Rules of Evidence closely regulate judicial notice of adjudicative facts, as do the evidence codes of the states that have adopted the federal rules, and those of several other states as well. Several states also have enacted statutes regulating judicial notice of law. So the rules of evidence closely regulate judicial notice of adjudicative facts. At least two factors complicate determining, of course, at least two, complicating determining whether a fact is adjudicative or not. First, the same fact may fit into several categories: the propriety of taking judicial notice and applicability of procedural rules will depend on the procedural setting at the time and upon how the court or jury uses the fact. So we can see that depending on your venue. But remember, the adjudicative facts here, right? Whether the fact is adjudicative or not applies to the parties, not to the population in general. The second complicating factor is that although common sense directs that a jury should be instructed that it must accept as conclusive any judicially noticed adjudicative fact, the federal rules of evidence require a judge in a criminal case to instruct the jury that it is not required to accept such a fact as conclusive. Perhaps as a result, some courts have declined to classify facts as adjudicative that probably should be so classified. Whoa, so you see that complicating factor there. This is quite interesting here because when you consider that, a lot of judicial notice that should be of the nature of adjudicative facts aren't because of the simple fact right here with the instructions to the jury, that the instructions tell them that they are not required to accept such fact as conclusive. And that's just for the adjudicative facts noticed judicially. But that there you can see why, another reason why it's used cautiously. This is also from the counsel standpoint. Judges don't like it because it takes away some of their discretion. Counsel doesn't like it because it could require them to notify a jury that they are not required to accept such a fact as conclusive. So, annotation. What constitutes adjudicative facts within the meaning? Concerning that's from American Law Review. Well, anyone has suggestions for looking at any of these references on a later live stream, let me know. And I'd be happy to present those too. Miami Trail Tours. Footnote 23. Usury versus. Wow, that's a strange one there. Which one was that referring to there? Yeah. Termination is particularly appropriate to administer which staffs of specialists and grade stores are available. Okay, I get it. It's not precluded from resolving issues of legislative facts. So, okay, so they still want to argue legislative facts. They don't like to judicially notice legislative facts. We already saw why they don't like that. It takes away discretion. Okay, so let's continue here. All right, State Supreme Court's use of chart of average automobile stopping distances at various speeds did not authorize trial judge in another collision case to take judicial notice of the information in the chart and to so instruct the jury. All right, we're on to section 30. Let's check over here to the chat. Greetings, Love Ministry. You're very welcome. Welcome to the show. All right, section 30, particular facts as adjudicative or non-adjudicative. All right, so now we can figure a way to not be stuck with these adjudicative facts that don't like to be noticed. Economic events, such as the governmental intervention into the oil industry, as well as the shortage of fuel in the late 1973 following the Arab oil embargo, are adjudicative facts within the meaning of the federal rules of evidence. The following facts, however, have been held or recognized as non-adjudicative. 1. A drug's classification as a controlled substance under a federal statute, since it does not relate to who did what, where, when, how, and with what motive or intent, nor is it a fact which would traditionally go to the jury. And so this is recognized as non-adjudicative. That's one fact. 2, a note and an order from the trial court in an earlier case in the same circuit as the Court of Appeals. Same circuit. See that? That's a big deal. We saw that in another one too, where if it's not in the same circuit, it's customarily taken as hearsay unless otherwise. And 3, state statutes or state regulations promulgated under a state statute. So if a state statute or regulations, that were promulgated under a state statute. So the state statute would be enough to say that these statutes or regulations they would apply. So let's see here. Comment, counsel should be aware that the judicial access to legislative facts is not subject to a limitation in the form of indisputability or to any other formal requirements of notice other than those already inherent in affording opportunity to hear and be heard, in exchanging briefs, and in any requirement of formal findings at any level. And that judicial access to legislative facts should leave open the possibility of introducing evidence through regular channels in appropriate situations. We read that before. It's another comment, and I think that's the it's odd. Is it the exact same phrase? I believe it is. Yep, right here. Here's our same comment. And that's footnote 24, and that came from advisory committee. Okay, so they're just quoting that thing over and over again because it applies in all these different situations. So the redundancy is always done with intent within American jurisprudence. All right, so now we're on to subsection B here, judicial notice of adjudicative facts. And here's section 31, generally. Indisputability. Remember, this is one of the, the 3 factors or 3 prerequisites. Definition. Adjudicative facts are simply the facts of the particular case. Okay, adjudicative facts are. So now we want to do a judicial notice of this as fact. So federal rules of evidence authorize judicial notice of an adjudicative fact only if the fact is not subject to reasonable dispute. Reasonable dispute. Such may be the case only if either of 2 conditions is satisfied. Here we go. So we have 2 subconditions now for this is under disputability, right? The fact must be generally known within the territorial jurisdiction of the trial court, so judicially cognizant, or 2, must be capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. Unquestionable sources, their accuracy. As such, the rule is consistent with the traditional view that traditional methods of proof should be dispensed with only in clear cases. So you have to have a clear case to dispense with traditional methods of proof. Consequently, federal courts take a cautious attitude with respect to judicial notice of adjudicative facts, requiring that the matter be beyond reasonable controversy. Wow. Beyond reasonable controversy. If a particular fact is indisputable and incontrovertibly true, however, a court will judicially notice that fact and inform the jury that it must accept that fact as proven. Although in criminal cases, the jury instruction is somewhat different. So, this is, indisputability. So, an adjudicative fact that is indisputable. If a particular fact is indisputably and incontrovertibly true, however, see, it's our exception here. This is where it makes, the rubber meets the road here, is where all these exceptions come into play. A court will, that's I guess the same as shall, a court will judicially notice that fact and inform the jury that it must accept that fact as proven, although in criminal cases the jury instruction is somewhat different, as we read before. In state courts, adjudicative facts may be judicially noticed if they are generally known, that is, well established, and authoritatively settled by persons of average or reasonable intelligence, good luck, in the jurisdiction in which the court sits, and indisputable or not subject to reasonable dispute. So that's in some state courts. Adjudicative facts may be judicially noticed if they're generally known, well established, and authoritatively settled by persons of average intelligence or reasonable intelligence. Interesting, average intelligence. In the jurisdiction, that could be pretty low there, in which the court sits, and indisputable or not subject to reasonable dispute. Some facts may be judicially noticed because they are notorious and indisputable, while others may be judicially noticed because they are well known and easily ascertainable. The prior revocation of a driver license is an adjudicative fact that judicial notice of the adjudicative fact may be taken in a civil license revocation proceeding. Judicial notice may not be taken, however, of adjudicative facts where a substantial liberty interest is involved in a criminal proceeding, or where attempts are made to bring in facts not generated within the particular adjudicative body involved. So the prior revocation of a driver license is an adjudicative fact and may be taken in a proceeding. And judicial notice may not be taken of facts where a substantial liberty interest is involved in a criminal proceeding, or where attempts are made to bring in facts not generated within the particular adjudicative body involved. So jurisdiction, known to judicially cognizable. All right, disputed facts are not in the same category as matters of common knowledge, of which judicial notice may be taken. Okay, so disputed facts are not in the same category as matters of common knowledge. In fact, a court is not entitled to take judicial notice of facts which are disputed. For example, a court may not take judicial notice of the adjudicative fact that asbestos and lung cancer in the same person are necessarily causally related, as this matter is subject to reasonable dispute. In addition, whether or not there is a conspiracy of silence in the medical community regarding malpractice is a subject of considerable debate, and a court may not take judicial notice that a conspiracy of silence exists. Disputed facts are also not in the same vein as the laws of nature. Geographic and historical facts, time, laws, and other matters of common knowledge. So disputed doesn't say anything. It says disputed facts are also not in the same vein as laws of nature, geographic and historical facts. I don't know about that. Time, laws, and other matters of common knowledge. Interesting there, footnote 57. Let's see, that's Elliott versus United States Fidelity and Guarantee Insurance. All right. It is clear that uncertainty or widespread difference in belief with respect to the fact in question will operate to preclude judicial notice thereof in both federal and state courts. So uncertainty, widespread difference in belief with respect to that fact will operate to preclude that judicial notice. So if there's any uncertainty, it is clear that uncertainty or widespread difference will preclude that judicial notice. The fact that a fact is judicially noticeable does not necessarily mean that the court should also take judicial notice of the inferences a party hopes will be drawn from that fact. Another caution there. And that's another reason to be cautious. Just because you get it noticed doesn't necessarily mean that they'll make the same inferences that you hope will be drawn from that fact judicially noticed. Word to the wise. Let's jump over here to the chat before we go through the footnotes here. Hey, Officer Murphy, greetings. Good to see you here. Let's continue. All right, so we have here the medical something. Trial judge could not properly take judicial notice that defendant's denial of staff privileges to plaintiffs could have no discernible impact on interstate travel of patients to receive treatment. Appeal after remand. Let's see here. It was improper for the trial judge in reducing jury's compensatory damage award to take judicial notice that media coverage of the result of the suit was fair. Oh, wow. It is not indisputable that veteran grand juries are less captive to the prosecutor than newly impaneled grand juries. Less captive to the prosecutor. Huh. That's an interesting one there too, involving the grand juries. High degree of indisputability is the essential prerequisite of judicial notice. The court stating in particular that its holding could not be extended to recidivist proceedings. As to judicial notice of common knowledge, generally see Section 33. Of course, to keep being referred there, let's get there. It is improper to resolve disputed issues of material fact by judicial notice. Yeah, we get that. All right, we're on to Section 32. Effect of rules and statutes specifying matters of judicial notice. Here we go back to the Rule 201 of the Federal Rules of Evidence. It is the only federal rule which applies to judicial notice. And of course, that great advisory committee has been there to clarify it the way they think we should see it. It applies only to taking notice of adjudicative facts, specifies when a court may and must notice such facts, guarantees all parties a right to be heard upon timely request before a fact is judicially noticed, and spells out how a judge is to instruct a jury as to the fact that has been judicially noticed. In addition, some states have enacted laws authorizing or requiring courts to take judicial notice of various specified matters. For example, a state statute may require courts of general jurisdiction to take judicial notice of municipal ordinances. May require courts. A state statute may require courts of general, interesting here, general jurisdiction to take judicial notice of municipal ordinances or of the laws of another state. We saw that sister state in there with the motions from the practice of pleading section there on the forms. A statute enumerating matters of which the courts must take judicial notice does not necessarily preclude a court from taking judicial notice of other facts which are commonly known and accepted. Wow, a state enumerating matters of which courts must take judicial notice doesn't preclude them from taking notice of other facts. Okay, well, that makes sense. All right, finally, we're on to Section 33, as promised. Facts of common knowledge. The law has long afforded judicial notice to a fact if it was a matter of common and general knowledge or notoriety. And it has been said that the courts are never justified in taking judicial notice of matters which are not. A fact might qualify for judicial notice because it is common knowledge everywhere. The basic appearance of a snowman, for example, is common knowledge. It would be pointless, therefore, in a patent infringement action to require a toy manufacturer to offer evidence of the traditional characteristics of all snowmen, and unjust to permit a jury to find that the company had infringed upon another's patent simply because the former, like the latter, distributed a toy that had those traditional characteristics. Thus, a trial judge could properly take judicial notice of those common features in ruling on a motion for summary judgment. Oh my gosh, footnote 74, was it really the snowman case? Hopefully that's rules of federal procedure. No, it is. Holy goodness. Eden Toys versus Marshall Field. So there's your, wow, the snowman case. Amazing. All right, there we go. We had the snowman case solved. In addition, the fact that it rains in Louisiana is a proper subject for judicial notice. Dictionaries, encyclopedias, and similar general reference works may be consulted to determine whether a particular fact is widely enough known to fall within this category of common knowledge. Alternatively, a fact might qualify for judicial notice within a particular jurisdiction because it relates to conditions within that jurisdiction. For example, facts concerning particular locations and neighborhoods within the jurisdiction of the court. It is not enough that the proffered proposition of facts is widely believed. Certainty is required. Judicial notice applies to self-evident truths that no reasonable person could question, truisms that approach platitudes or banalities. A court's taking of judicial notice that a fact is generally known is not conclusive proof that a particular individual was aware of that fact. If the matter relates to specialized knowledge, judicial notice is appropriate if the fact in question is well known and generally accepted in specialized areas among those members of the public who deal with such matters. This is particularly true in the scientific field, so that common knowledge is not necessary if scientists agree that the essential element of certainty exists. Section footnote 83. Niketa versus National Tea Company. A trial judge properly took judicial notice that the parasite that produces trichinosis is destroyed when pork is properly cooked, and dismissed plaintiff's cause of action alleging that they became infected with trichinosis after purchasing fresh pork from defendant and properly cooking it. Judicial notice can be taken of the common knowledge that oil can seep through the ground. Properly cooked is destroyed when pork is properly cooked. Cook your pork. Interesting. All right. All right, so we get that the pork out of the way here. Care must be taken in applying common knowledge aspect of judicial notice to distinguish between decisions taking notice of adjudicative versus legislative facts, because the degree of certainty sufficient for legislative facts is not sufficient for adjudicative facts. Okay, this one needs to be split a little bit more finely, and this is why I like American jurisprudence, because we'll keep hammering at this distinction between adjudicative and legislative facts. Because remember, the adjudicative are applying only to the parties and the specifics of the case, who, what, when, why, and all that. The legislative are the ones that apply within the jurisdiction. Because of the degree of certainty sufficient for the legislative facts is not sufficient for adjudicative facts. A court should not be particularly wary of taking judicial notice of sociological facts as adjudicative facts. Such self-evident truths, sociological, often become hotly disputed political issues and are often ultimately rejected, of course, and supplanted by newer truths. Newer truths, I like that. Newer truths. This is a great term right here. As if. Finding that these matters are not matters of common knowledge, courts have refused to taking judicial notice of an attorney's overhead or expenses and determining the amount of fees to award counsel. Oh boy, talk about jumping the gun. Whether a particular school is an elementary, vocational, or secondary school. Wow, they didn't take judicial notice on that. A redevelopment project's proximity to leased premises. The side effects of Regratrin, blood pressure medicine, and the causes and effects of relaxation of the arteries. See, another one is facts contained in expert testimony and prior similar child custody cases before a court. Remember, none of these are not matters of common knowledge, and the courts have refused taking judicial notice on these points here. In addition, judicial notice may not be taken of a custom or usage, local in nature, without the proof of its existence and application. So you're back to giving proof of your evidence. Proof of facts. Consequently, the possibility of selecting an impartial jury in a particular county is not a proper matter for judicial notice. Furthermore, while a court may take judicial notice that Aspen, Colorado is located in the Colorado Rocky Mountains, it cannot take judicial notice that on a flight from Nashville, Tennessee to Aspen, a plane would have to climb from 6,500 feet to 17,500 feet, as this is not a fact a court may act upon without proof. Interesting case there, 92. Did they fly high enough? Let's see here. Omni Aviation versus Perry, Tennessee. All right, we're on to section 34, facts capable of accurate and ready determination. All right, so let's see here. Federal rules of evidence. Well, before we get to this, let's jump over to the chat and make sure we're all up to date here. Is everyone still with me? This has been another dense, full of information, but a lot of learning going on. So if you guys did get the notification, I'm glad you're here. And please hit the like so we make sure everyone gets that notification for the next one. All right. So we're on to the facts capable of accurate and ready determination. The federal rules of evidence authorize, and in appropriate circumstances require, a court to take judicial notice of an adjudicative fact that is not subject to reasonable dispute, in that it is capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. In contrast with judicial notice of matters of common knowledge, notice of ascertainable facts is a comparatively new development in the law. Wow, that's an interesting one. Ascertainable facts, ready determination. Numerous cases can be found in which courts judicially notice historical, scientific, geographical, and topological facts, except for that mountain we were talking about there before, phenomena of nature, seasons and plants, time, customs, except for when you can't, usages of businesses and professions, and actions of government bodies and agencies. So this is, again, notice of ascertainable facts is a comparatively new development in the law. News usually not good when we're talking about the law. Judicial notice is improper, however, if a legitimate question exists, either as to the information itself or its underlying source. Remember, it has to be no reasonable question about the accuracy of the source. Matters not of common knowledge may be judicially noticed if they may be readily determined by an examination of a source whose accuracy cannot be reasonably questioned, such as geographical and historic data. Historic data can be questioned usually, and scientific facts which are generally accepted as irrefutable by living scientists. Oh, Lord. So that means the dead ones are wrong? In other words, taking judicial knowledge of any fact is subject to the test of verifiable certainty. For example, a court may take judicial notice of the location of cities, counties, boundaries, dimensions, and distances because geographic facts such as these are easily ascertainable and capable of verifiable certainty. Okay. So that makes sense, but these are facts that are capable of accurate and ready determination, ascertainable facts. And we're on to section 35, judicial as distinguished from actual knowledge. So remember, there is judicially cognizable. In the federal courts, a judge must take judicial notice of a fact, although it is not within her knowledge, if the fact in question is one which is the proper subject of judicial cognizance, and the party seeking to have the fact noticed has provided the necessary proof, because the federal rules of evidence require the judge to take notice under these conditions. Therefore, it is inappropriate for a judge to rely solely on personal knowledge in ruling on a pretrial motion, a suppression hearing, or on the merits, although a different rule may be applied in Social Security cases. Now that's interesting. In Social Security cases, if proper notice and opportunity for rebuttal are given, an administrative law judge may take judicial notice of adjudicative facts within her personal knowledge. Opportunity for rebuttal are given, though. In state courts, even though facts are known to the judge personally, they must be proved by evidence, unless they are matters of which judicial notice may properly be taken. Thus, it is said that judicial notice in any particular case is not determined or limited by the actual knowledge of the individual judge or court. In other words, the individual and extrajudicial knowledge on the part of a judge will not dispense with the proof of facts not judicially cognizable, and cannot be resorted to for the purpose of supplementing the record. So, in other words, the individual and extrajudicial knowledge on the part of a judge, the judge's individual and outside the judicial, extrajudicial knowledge, will not dispense with proof of facts not judicially cognizable. So just because a judge doesn't know about it individually or outside his knowledge of a judge as a judge will not dispense with proof of facts that they're not aware of or able to know of, and cannot be resorted to for the purpose of supplementing the record. So they can't even add a supplement about the fact they don't know about it. Therefore, judicial knowledge upon which a decision may be based is not the personal knowledge of the judge, but the cognizance of certain facts the judge becomes aware of by virtue of the legal procedures in which the judge plays a neutral role. Footnote 18. Vaughn versus Shelby Williams of Tennessee. It does not matter what is known to the judge personally if it is not known to the judge in her official capacity. Consequently, a judge may not take judicial notice of a person's sense of humor, which is not a part of the evidence nor a fact generally known within the territorial jurisdiction of the trial court, unless they're a comedian, and which is not capable of ready determination by resort to sources whose accuracy cannot reasonably be questioned. A fact must be fairly well known and obvious before judicial notice of it can be taken. You better be a good comedian if you want them to take judicial notice of your sense of humor. A high degree of indisputability is the essential prerequisite of judicial notice. Although no judge is at liberty to take into account personal knowledge which the judge possesses when deciding upon an issue submitted by the parties, judicial notice may be taken of adjudicative facts under limited circumstances, provided those facts are not subject to reasonable dispute. Okay. Furthermore, facts within the personal recollective knowledge of the judge may be judicially noticed if those facts are generally known in the jurisdiction. In addition, in some jurisdictions, a trial judge may take judicial notice of a collateral fact of which she has personal knowledge. Some jurisdictions may take judicial. That's strange for them to do it themselves. The proper test is whether the fact to be judicially noticed is verifiably certain. Under this test, a judge may personally know a fact of which she may not properly take judicial notice. It's not verifiably certain. A judge may use authoritative sources to refresh her memory upon matters properly subject to judicial notice. But the mere appearance of facts within publications such as encyclopedias, textbooks, and dictionaries does not, in most jurisdictions, mean that such facts can be judicially noticed unless they are part of the common knowledge. So obscure textbooks and such wouldn't be qualified for judicial notice. Trial judge personally knows is not a fact. He can judicially notice to cure an otherwise defective search warrant affidavit. A trial judge's personal knowledge of an informant's reliability is not a fact. He can judicially notice to cure an otherwise defective search warrant. Affidavit. Wow. He's reliable. It's like, nah, it's defective. That was Florida, huh? This is Lewis. Interesting. Criticize on other grounds. Okay, so those are just references to those cases. A judge may not use from the bench, under the guise of judicial knowledge, that which the judge knows only as an individual observer outside of the judicial proceedings. The trial court took judicial notice of expert witnesses' infirmity for purpose of admitting experts' deposition. Okay. So someone's saying that I'm infirm, and this is what it's like being infirm, I guess, something to that extent. And they had to have judicial notice that, yeah, we have an infirm witness here. So when he talks about infirmity, he knows what he's talking about because we can see he's infirm. All right. So we'll go on next time to subsection 2, procedural issues, starting with the general section. So a little preview of what's to come. And that will be on the next one. So let's jump over here to the chat and see where we left off. Again, we had Officer Murphy, and if you're still here, I hope we still have enough people that were able to stick around for this because it has been a very long presentation. We've been on for quite some time. If you are still here, please hit the like and make sure the algorithm gets out there to know that people are interested in this. And I salute you all for spending the time to be here and to review the law of evidence and judicial notice with me here tonight. With that said, I just want to remind everyone, if you want to join the membership level of Audit Shield on the Auditor's Shield on this channel here, that you'll get some of the great benefits of the Auditor Shield program here. You'll get a custom FOIA audit package if you send us the state you're in and an email address, and that will include custom forms, templates that would apply directly to your state FOIA. We also have members-only FOIA tutorials on the channel here in the members-only section, which will help you understand the FOIA process and break it down into its elemental steps and get you auditing like a pro. Also give you priority responses both within the live streams and in special members-only videos where we'll be able to give some straight assistance. And of course, you'll get the exclusive badge and customs emojis to show your commitment to transparency in government. Because FOIA and auditing is really the way of ensuring that the government is functioning in the public interest, and it's the people's duty to make sure that that is occurring. So I would encourage you, if you are so inclined, to join the Auditor Shield membership level on the Tribe channel. That being said, I thank you all for attending tonight, and we'll see you all on the next one. Peace out.